which may be of interest. I have received a letter from the Honourable Ruth Dyson seeking to debate under Standing Order 380 the release by the Minister of State Services, the Honourable Tony Ryle, of the second six-monthly update on the government's cap of core government administration and the associated announcement of the cut of 135 jobs at the Ministry of Health. As has been ruled on many occasions, a continuing issue cannot give rise to a debate under Standing Order 380. The government's cap on core government administration has been in place since 2009, and the Minister's announcement in his second six-monthly update For there to be a particular case of recent occurrence, there must be either a new situation of importance or a new development in an existing situation of sufficient importance in itself to warrant a debate being held, Speaker's Ruling 174.4. As there is no new development that is of sufficient importance in itself to warrant the putting aside of the business of the House immediately, this application for urgent debate is declined. I call on Government Order of the Day number 1.
Judicial Conduct Commissioner and Judicial Conduct Panel Deputy Commissioner and Disposal of Complaints Amendment Bill, District Courts, District Court Judges Amendment Bill, Judicature, Judicial Matters Amendment Bill, third reading.
The Honourable Chris Finlayson.
Mr. Speaker, I move that the Judicial Conduct Commissioner and Judicial Conduct Panel Deputy Commissioner and Disposal of Complaints Amendment Bill, the District Court Judges Amendment Bill and the Judicature, Judicial Matters Amendment Bill be now read a third time. These three bills emerge from the division of the Judicial Matters Bill, and I'll deal with them one by one. The first is the Judicial Conduct Amendment Bill, which amends the Judicial Conduct Commissioner and Judicial Conduct Panel Act 2004. The Office of the Judicial Conduct Commissioner provides a public and transparent judicial complaints process while upholding the principle of judicial independence. The bill makes three changes. First, it creates the position of Deputy Judicial Conduct Commissioner, who's going to be appointed in the same manner as the Commissioner, that is, by the Governor-General on the recommendation of this House. The Attorney-General is required to consult the Chief Justice on the proposed nomination prior to the debate in the House. The Deputy Commissioner is going to be able to conduct a preliminary examination of a complaint when the Commissioner has a conflict of interest regarding the complaint or is otherwise unavailable. Secondly, the bill allows the Commissioner to dispose of a complaint if in all the circumstances further consideration of the complaint is not justified. This is appropriate where the complainant is satisfied following an explanation or apology from the judge. However, even though the complainant may be satisfied by the judge's explanation or apology, the Commissioner may still decide that further consideration of the complaint is required. In making the changes on the disposal of complaints, the opportunity has been taken to do a number of other things to clarify some reasons why the Commissioner may take particular actions, set out the actions available to the Commissioner in the sequence of the Act as amended by this legislation, and update Schedule 1, which provides a diagrammatic overview of the complaints process. Finally, the bill states that the amendments don't apply to complaints lodged prior to the commencement of this legislation. Consequential amendments are also made to the Coroners Act 2006 and the Official Information Act of 1982. The amendments strengthen the Act's primary objective of the prompt handling of judicial complaints and are based on the previous Commissioner's recommendations in his annual reports to Parliament and are endorsed by the present Commissioner. The second bill, sir, is the District Court Judges Amendment Bill, which amends the District Courts Act 1947 to increase the statutory limit on the number of judges who may be appointed from 140 to 156. This limit includes all judges holding a District Court judicial warrant. These are judges of the District Courts in its specialist divisions as well, the Family Courts and the Youth Courts, as well as judges of the Environment Court and the chairperson of of the proposed new Immigration and Protection Tribunal. Currently, 2 judges of the Employment Court hold warrants as District Court judges, as do the Chief Coroner and the outgoing Principal Disputes Tribunal referee. Since coming into office, this government has progressed and continues to progress significant legislative and policy initiatives which are aimed at making New Zealand a fairer and safer society. The effective implementation of these initiatives, particularly those arising from the government's 100-day action plan, will require increased judicial resources, and this need is primarily in the district courts. The bill amends the District Courts Act to increase the statutory limit, and it's the first increase since 2004. And while meeting the judicial resource requirements flowing on from the government's initiatives, the increase will also allow some scope for future appointments. The final bill's the Judicial Matters Amendment Bill, and that makes 3 amendments to the Judicature Act 1908. First, it confirms that High Court judges serving as acting judges of the Court of Appeal should receive the same remuneration for that period of service as the permanent judges of the Court of Appeal. The bill also validates past payments made in these circumstances. High Court judges provide a valuable supply of additional judicial resource to the Court of Appeal, especially for hearings in both the Criminal Appeals Division and the Civil Appeals Division. In addition to ensuring the Court of Appeal can get through its heavy workload, High Court judges are able to share their current experience in conducting trials while gaining insights into the appellate process. While serving in the Court of Appeal, High Court judges receive a higher duties allowance, and that's calculated, sir, on a per diem basis on the difference between the salaries of judges of the 2 courts as determined by the remuneration authority. While the payment practice is consistent with the principles of judicial independence, in 2008 the High Court in Wikio and Beckham and the Attorney General expressed the view that the payment of an allowance to a High Court judge sitting in the Court of Appeal should rest on a more secure constitutional foundation than is apparent from the available evidence, and the amendment addresses this concern. And I just want to note that there was a very helpful discussion in the committee where members of all sides raised a number of points, and the concerns expressed by the Labour opposition about the placing of judicial salaries on a constitutional footing, or a more sound constitutional footing, is certainly noted. Secondly, sir, the bill increases the current statutory limit on the number of associate judges of the High Court who may be appointed, and this increases from 6 to 9, the first increase for many years. The office was created in 1989, and associate judges have made a valuable contribution to civil proceedings in the High Court. As I noted in my second reading speech, the increase in the cap, together with the recently announced court-assisted mediation pilot and the recent improvements to the High Court rules, will ensure adequate judicial resources are available to meet the increasing demands of the High Court's workload. Lastly, sir, the bill amends the statutory limit of Court of Appeal judges so that the maximum number, including the President, is increased from 9 to 10, and this is to meet the increasing workload of the Court of Appeal. The statutory limit was last increased in 2006. In conclusion, Mr. Speaker, the amendments set out in these bills are important improvements to enhance public confidence in the judicial complaints process and will ensure our courts are adequately resourced. And can I thank members once again for their collaborative spirit in discussing some of the important constitutional issues addressed by this legislation. I commend the bill to the House.
The question is that the motion be agreed to. Charles Chauvel.
Thank you, Mr. Speaker.